In this video, we're going to look at the problems of contract formation in the form contract setting, the so-called Battle of the Forms. In commercial settings, it is very common for companies to have their own forms with standard terms for the purchase or sale of goods. Instead of negotiating every term of every contract, the buyer will typically just send off a form, usually called a purchase order, to the seller. On the front of the purchase order, the buyer will have typed or written in the particular terms of sale, generally things like quantity, subject matter, and price. These are called the Dickard terms. On the back then, there will be a bunch of standardized, pre-printed terms called the boilerplate. The boilerplate generally contains extensive additional terms and conditions governing matters like shipping, resolution of disputes, warranties, and cancellation procedures. If the seller were simply to accept or acknowledge the buyer's purchase order, then a contract would be formed on those terms. But that rarely happens. Instead, the seller generally responds with its own form, usually called a sales order or acknowledgement. The face of the acknowledgement, where the quantity, subject matter, and price are specified, will often correspond with the face of the purchase order. But the seller's acknowledgement typically will have its own boilerplate on the back, setting out pro-seller terms. The business people, the sales and purchasing agents at the two companies, don't know or care about the boilerplate terms on the back of the forms. They are focused only on the Dickard terms. So at this point, the seller and buyer usually just file away the forms and proceed with the sale. Generally, things move forward without any problems. However, if a dispute arises and the relevant boilerplate terms are different on the two forms, the question becomes, which terms govern? Under the common law, the courts use the standard rules on offer, acceptance, and counteroffer. When an acceptance is not the mirror image of the offer, it is treated as a counteroffer, which must be accepted by the original offeror before a contract is formed. Since performance can constitute acceptance, the party which happens to send its form last always wins. This is called the last shot analysis, and it is considered to be unfair because it gives all the advantage to the party who by chance sent the last form. Recognizing the arbitrariness of the common law rule in this setting, the UCC developed a new approach to the problem of the Battle of the Forms, making drastic changes in the mirror image rule. Open your book to UCC 2-207 so you can see the basic structure of the rule before we get into more detailed questions of interpretation. UCC 2-207-1 governs when a response which purports to be an acceptance but contains terms which are different from or additional to those in the offer can act as an acceptance. It also describes how the offeree can prevent his response from becoming an acceptance. Subsection 2 governs when the additional terms in the offeree's acceptance become part of the contract. Note that you only reach this subsection if you first determine that a contract has been created under 2-207-1. Subsection 3 governs when conduct by the parties can establish a contract even though their writings do not. It also identifies what terms are included in such contracts. You only reach this subsection if you first determine that a contract has not been formed under 2-207-1. The UCC provision attempts to find a compromise between the two forms, making it more fair between the parties. It treats the offeror's form as the base contract, but creates the possibility for the offeree's additional terms to be included in the contract as well. In trying to reach this compromise, the rule became very complex. Let's look at a simple flow chart. You always start with subsection 1 to determine whether a contract was created by the exchange of forms. If a contract was was created, then you go to subsection 2 to determine whether any of the offeree's terms become part of the contract. If, on the other hand, a contract was not created, then you go to 2207(3) to determine whether the parties created a contract based on their conduct, and if so, what terms that contract contains. You never use both 2 and 3. It is either or. Okay, let's begin with 2207(1). Under subsection 1, you need to do 2 steps. First, you need to ask whether there was a definite and seasonable expression of acceptance. If there was, then, second, you need to ask whether the offeree made its acceptance expressly conditional on assent to the additional or different terms. Okay, so our first step is to determine whether there was a definite and seasonable expression of acceptance. To determine whether there was, you need to address 3 things. To be seasonable, the acceptance must be timely. To be definite, the courts look at whether the response indicated a willingness to commit to the contract and whether it was consistent with the offer with respect to the key terms being negotiated, such as quantity, price, and subject matter. Again, these terms are often referred to as the Dickard terms. If there was a definite and seasonable expression of acceptance, then you have a contract based on the forms, despite the fact that there are different or additional terms on the back. However, the final clause of subsection 1 gives the offeree an opportunity to block formation of a contract by making its acceptance expressly conditional on assent to the additional or different terms. So an offeree can prevent its responding form from serving as an acceptance by including language in its own form saying that its acceptance is conditional on the other party's assent to the additional or different terms contained in the offeree's own form. The courts, however, have adopted a very strict rule on what the offeree needs to include in its form. Under what's known as the Dorton approach, in order for an acceptance to block formation of a contract, it is not enough that an acceptance is expressly conditional on the additional or different terms. Rather, it must be expressly conditional on the offeror's assent to these terms. This is a formalistic rule which is designed to make it easier to form a contract under subsection 1. Under this rule, the offeree must use the magic words, that is, words that closely track the language of the rule itself. If the offeree uses the magic words, then no contract is formed unless the offeror specifically and unequivocally agrees to the offeree's terms. As a practical matter, that never happens. Why? Because the business people are not even reading these forms. Here's an example of how strict the rule is. Okay. If the offeree's form says, "Our acceptance is conditional on the terms printed on the back of this form," that language is not sufficient to block formation of a contract because it does not make acceptance conditional on the other party's assent to or acceptance of the additional terms. Instead, the form would have to say, "Our acceptance is conditional on your assent to the terms printed on the back of this form," or "Our acceptance is subject to your acceptance of the terms printed on the back of this form." At this point, you reach a fork in the road. If you have determined that the contract was formed under subsection 1, then you proceed to subsection 2. If you have determined that a contract was not formed under subsection 1, either because there was not a definite and seasonable expression of acceptance, or alternatively, the offeree used the magic words and has a valid conditional on assent clause. So if a contract was not formed, then you proceed to subsection 3. Remember, you never do both. We'll start with what happens if a contract is created by the exchange of forms. If a contract was formed under 22071, then you must determine whether the disputed term is part of the contract. To do that, you must figure out whether the disputed term is additional or different from the terms of the offer. Why does this matter? Because the rule treats additional terms differently than different terms. Take a moment and look at the wording of 220.7 sub 2. It contains a drafting ambiguity. It specifically addresses additional terms but says nothing about what to do with different terms. The rule itself tells us how to handle additional terms, but the courts have had to figure out on their own what to do with different terms. Before we look at the details, let's see how you distinguish between additional and different terms. A term is additional if the offer is silent on the subject. A term is different if the offer contains a term on the subject that this term conflicts with. But note, some courts treat the offer as including all UCC gap fillers. The effect of this is that a term is different if it conflicts with a gap filler that is implied in the offeror's form. Okay, so here's a couple of examples. Let's say the offeror's form is silent on warranties. The UCC has a gap filler on warranties, so the court would say that the gap filler was part of the offeror's standardized terms, and then if the offeree's form has a different warranty term, that term would be different from rather than additional to the offeror's original form. Okay, under UCC 22072, the rule tells us how to handle additional terms. We'll start there. Once the court has determined that a contract was formed under subsection 1, the base contract is the terms of the offer. Subsection 2 distinguishes between situations where the parties are and are not merchants. So you need to make that determination. We'll follow a simple rule. The parties are merchants if both parties are in business. If the parties are not merchants, the offeree's additional terms will be considered proposals for addition to the contract, which the offeror can accept or reject as she pleases. As a practical matter, this means that the additional terms will not become part of the contract. It's more of a pretty please. But also, in practice, only businesses use form contracts, so the battle of the forms almost always involves merchants. If the parties are both merchants, the additional terms will become part of the contract unless the offeror can show one of three things: that the offer expressly limits acceptance to the offer's terms, that the additional terms materially alter the contract, or the offeror notifies the offeree that he objects within a reasonable time. Again, we see the UCC here trying to seek a fair balance between the forms. The offeror's form is the base contract, but the offeree's terms can be included unless one of these three things applies. Let's look more carefully at the three options. The first is where the offer expressly limits acceptance to the offer's terms, the my way or the highway type of term. In order for this term to be valid and effective, the offeree must use the magic words indicating that it expressly limits acceptance to. For example, the court found that a clause met this standard where it said, quote, important, This order expressly limits acceptance to the terms stated herein, and any additional or different terms proposed by the seller are rejected unless expressly agreed to in writing. Note how closely this term tracks the UCC's language. The second way in which an additional term will be dropped out of the contract is when it materially alters the contract. The standard for material alteration is surprise or hardship. In comments 4 and 5 to the UCC code provision, the drafters tell us that surprise means something unexpected, and hardship means that it poses substantial economic hardship. The comment also provides examples, most of which focus on whether the additional term is within customary ranges for that particular industry. The third way in which an additional term might be left out of the contract is if the offeror notifies the offeree that he objects to that term within a reasonable time. The standard here for an objection is that it must be an express, specific objection to the offeree's term. This rarely happens, again, because no one is reading the forms. Now let's look at what the courts are doing to handle different terms. UCC 2-2072 is silent with respect to the status of different terms, but the cases and commentators have suggested 3 different approaches to the problem. The first approach is to treat different terms as included under the aegis of additional terms in 2-2072. The rationale for this approach is that the drafters of the rule probably meant to refer to different terms in subsection 2, and the omission was just an oversight. Under this approach, different terms almost never become part of the contract because, by definition, different terms materially alter the contract. Several courts have adopted this approach. Under the second approach, courts treat 2-2072 as meaning what it says. It applies only to additional terms, so different terms simply drop away. Because these first 2 approaches almost always lead to exclusion of the different term, they impose a first-shot approach, giving all the advantage to the party which happens to send the first form. Courts have thus developed a third approach to different terms, which is called the knockout rule. Under the knockout rule, the conflicting terms cancel each other out. In other words, the offeree's response is treated as an acceptance only of the terms of the offer which do not conflict. The ultimate contract then consists of the non-conflicting terms plus any of the UCC's supplementary terms, which include trade usage, course of dealing, course of performance, and gap fillers. Even though this approach is not supported by the language of the rule, the majority of courts have adopted it. Why? Because it is most consistent with the UCC's purpose. It levels the playing field by not allowing either form to take precedence. For this class, you may assume that our jurisdiction follows the knockout rule. This knockout rule is the rule you need to know for the exam. All right, now let's look at what happens if a contract was not formed under 2-2071. In that case, you go to subsection 3 to determine whether a contract was formed by the party's performance, and if so, what terms the contract contains. Now, a contract might not be formed under subsection 1 for either of 2 reasons. First, the offeree might not have made a definite and seasonable expression of acceptance. For example, its responding form might be different with regard to one of the Dickard terms, such as quantity or price. Second, the responding form might fail to form a contract because it contained the magic words and successfully blocked formation of a contract. In other words, it became a counteroffer. If either of those things happen, we have an offer and a counteroffer but no acceptance. Either party can walk away at that point and no contract is formed. But in many cases, the parties go ahead and start performance anyway. If that happens, subsection 3 tells us that a contract is created based on the parties' conduct if they perform. Subsection 3 also tells us that the terms of the contract are the terms on which the writings of the parties agree and any supplementary terms from the UCC. That means the gap filler provisions in the UCC plus terms that can be implied from trade usage, course of dealing, and course of performance. In other words, we use the knockout rule here as well. This concludes the video. Thanks for watching, and I'll be happy to answer questions in class.